the AMC Workshop Wednesday. Thank you for joining us and welcome. My name is Dwayne Williams. I'm Vice President of Marketing for AMC. We're excited to have you here today. We've got a very exciting topic today, how to deal with difficult board members. But before we begin, let me just start with a few general housekeeping notes on Zoom. First of all your mics are muted and your cameras are also turned off. If you'd like to communicate, please do it by chat, all right? And we're going to take the question and answer session during chat one at a time in order of your name and the time that you appeared, all right? So that's it as far as that goes. I'd like to take a moment and send out a special thank you to Ron Lee, who helped us last time with our workshop. So Ron, thank you very much. Now, without further ado, I want to talk a little bit about the workshop today. Our guest speaker is Attorney John Hansen. John has extensive experience in working with HOA boards throughout the country. He has over 10 years experience in dealing with difficult situations, just like the ones that we're talking about today. So without further ado, I'd like to introduce Attorney John Hansen.
Thank you, Dwayne, and thank you to AMC for allowing me this chance to speak today, and for you all for joining us today about a great topic that I think will resonate with all of you and give you a chance to walk away with some tips and some tools for how you can deal with difficult directors. As Dwayne mentioned, I represent homeowner associations. I've been doing this for a number of years and have experience dealing with a variety of conflicts amongst boards with homeowners, amongst boards with really all kinds of situations, and can offer some tips and some examples that will help you find ways that you can resolve conflict and deal with those difficult directors. My background is 100% in HOAs. I have a criminal background long before I started doing HOA work, but my practice area now focuses 100% on homeowner associations. So I understand the unique situations that you face. We're going to start today with talking about the good traits that we find in board members that I'm sure a lot of you will understand because you've heard about them in other presentations as well, dealing with fiduciary duties and how you make decisions. So we're going to start with those foundational principles before we get into the things to not do and how to deal with those scenarios. So starting with our foundational principles of directors. Directors are fiduciaries of a corporation. You have a fiduciary duty. It's a term that's used a lot in these kinds of presentations, but it's important to remember this is the highest duty of care imposed by California law. There are very few individuals who are considered fiduciaries. Attorneys are one of them, trustees, certain types of agents like your managing agent that have this fiduciary duty. And it means you are placed in a position of trust. You are entrusted with the members and the association's assets, the value of the common area, the value of all the homes, all of the assessments. So it's an important duty that is placed on you as a volunteer director. And so our directors hopefully are all taking that duty seriously as they represent and manage the association. Part of that duty is a duty of trust. As I mentioned, you are entrusted with the association and the members' assets, but also a duty of loyalty, that you are placing the association's interests above your own. That even if it's not something that you particularly are excited about, you recognize that it's good for the association. And the common example that I often use is raising assessments. Nobody wants to pay more on a monthly basis. No one wants to have their bills go up. But you may recognize if the association has bills to pay, has insurance to pay, has maintenance to carry out. And so you know that the association is best served by raising assessments, even though you are stretched thin. You don't want to spend more money. You still make the decision to raise the assessments if it's the right answer. That duty of inquiry is part of that fiduciary duty, to do your diligence, to speak to your experts, to read your board packet each month, to get advice before making a decision. That is part of that fiduciary duty, is doing that due diligence when you make decisions. Again, to summarize that, is that duty of care, loyalty, and inquiry. Those are wrapping up what we see in a director who's carrying out their fiduciary duties, the good board member, we're going to call them. The good board member is also carrying out decisions by a majority vote, that once the majority decides it, even though they may not like it, they're going to follow that majority decision. They're not unilaterally acting. They're not trying to undermine a majority vote once it's carried out. And they're recognizing that the board is a group and a majority rules. The question that I often get when I mention that majority vote issue is, well, what if the board does something crazy? Do I have to follow it? And the answer is no. If the board said, we're going to sell the clubhouse and take the money and go to Las Vegas and bet it on black, and we're going to double our reserves, the answer is no. You don't go along with that decision. That's part of your fiduciary duties too, is to know when, okay, there's decisions where there's reasonable minds can differ, and there's decisions that just flat out violate the law or violate your duties completely. Then, of course, you should take a stand against that, not participate, try and get the association back on course. But when it's a decision about whether or not to have a parking rule or whether or not to pick one vendor over another in a competitive bid process, when reasonable minds can differ, majority rules and the rest of the board should support that majority decision. A good board member is also recognizing that they can't do everything. You can't manage every aspect of the association, even though you oversee it. There are certain things that you're going to be delegating to your management staff. You're going to delegate to your management company the obligation to collect assessments or to manage the financials, to carry out maintenance. You're going to give them that authority because they're in a position to do it, because that's their job. And they have the resources and the experience to do it well. As a board member, you're also going to rely on committees at times. Not all the time, but sometimes you may have a committee that you say, landscape committee, we want you to be in charge working with the landscaper on renovating the landscaping at the entryway to the development. You can rely on those committees and delegate authority to them, because that also helps you in managing your workload as a director. And then again, relying on experts. This is going to come up several times in this presentation, in part because you aren't called to be an expert when you serve on the board, but the courts actually give great emphasis and weight to boards who rely on their experts. Legal, CPA, your contractors, your landscapers, your insurance professionals, those experts are there to help you as a board member carrying out your decisions and making informed choices. The good board member is following the business judgment rule. And the business judgment rule is a re-articulation by the courts of those fiduciary duties we mentioned before. But the business judgment rule takes it a step further. It gives you both a framework for making decisions, but it also gives you some protection from liability, both individually and as the association, when you make those decisions. And what the business judgment rule says is that if a board makes a decision in good faith, so you think you're doing the right things for the right reasons, upon reasonable inquiry, so consulting with experts, doing your diligence, reading up on things, and in the best interest of the association, if you meet these criteria, not only are you protected from liability, but you'll have what's called the rule of judicial deference, which means a court is going to say, association, even though you may have made the wrong choice, you made it in the right way. You fulfilled these steps of this business judgment rule, and therefore we're going to rule in favor of you in this particular lawsuit, for example. And the case that illustrated this point is called Lambden versus La Jolla Shores. You may have heard about it before, but very briefly, in this case, the condominium development had termites. Mrs. Lambden complained about it. She said, board, you have termites, you have to fix it. They're damaging my unit and the entire building. The board looked at it and said, you're right, we have a termite problem. We have to deal with it. So the board consulted with an expert. The first pest control expert said, the only way to deal with the termites is a type A treatment, which means all the people, pets, and food come out of the building. You have to tent it and fog it. It's the only way to deal with the termites. The board considered that and thought it's going to be very expensive. It's going to be very inconvenient to our homeowners. And we want to get the termite problem solved, but this seems like it's a lot for us to do. So the board consulted with expert number two. Expert number two said, I agree with the first guy. Type A treatment is the only way to go to really resolve the problem. But you could try and do a type B treatment or a spot treatment, where anytime you see evidence of termites, you spray in the area. That might solve the problem. It probably won't, but it might. It'll cost you less and everyone can stay inside their units. The board considered that and said, great, let's go with option number 2. It's going to cost us less. It'll be the least inconvenient choice for the homeowners. They can stay inside their units. They don't have to get their pets and their food out, and it may solve the problem. Well, it turns out it didn't. The termites got worse, and Mrs. Lambden sued. The court ruled in favor of the association by applying this business judgment rule, and it found that the board had acted in good faith. They had consulted with experts, and they were acting in the best interest of the association as a whole. They were trying to solve the termite problem in the most cost-effective and least inconvenient way possible. Now, the Lambden case is interesting because the board didn't actually follow the expert's advice. I wouldn't test that theory too far because that can get you into trouble. But nonetheless, it shows the importance that the courts place on that consultation with experts. So now let's flip the coin and look at the difficult board member. The difficult board member is one that acts unilaterally. They're making decisions on their own. They're going out and telling the landscaper, hey, you're doing it wrong. You need to come out twice more a week. You need to fix this. You need to do that. They're out there acting without any authority of the board, acting unilaterally. They're harassing or blaming other directors. The term harassment gets thrown around a lot, probably a little bit too much, I would say. But nonetheless, that feeling of a board member who is getting in your face, who's emailing, demanding and threatening emails, whose tone in general is often abrasive and combative, saying that past boards have screwed everything up, including some board members who were on those past boards. A lot of that type of acrimonious action is part of this, what we see in a difficult director. Refuses to vote, won't show up at meetings, says I'm not going to vote on something because I didn't read the board packet on time, not contributing to the cause, not contributing to serving the association. Makes baseless gut decisions, decides to hire a contractor without going out to bid formally, or just goes with what they think is the right answer without doing their diligence, without speaking to legal counsel, without speaking to management staff or your insurance broker. I've come in often when the decision's already been made and then the problem happens. And my first question is, how did the board get to this place? And they thought, well, this is what we thought. And they just kind of went with their guts, and turns out it doesn't always work out great. And so that can get boards into trouble. Disrupting meetings, interrupting other directors, not allowing the meeting to flow, interrupting the agenda, wanting to get off track on issues. Sharing privileged information, going out to the homeowners and saying, here's what the board did in executive session. I can't tell you how many times I've seen that post on social media or on Nextdoor, or seen that email blast go out where a board member is sharing privileged information, either attorney-client privileged or private information in executive session about maybe a litigation or a dispute with a contractor or violations of a homeowner. I mean, using board meetings as a soapbox, using those board meetings to get out and sort of grandstand in front of the members, using it as more of an opportunity to kind of make their point in front of the homeowners rather than use that board meeting to conduct business. So back to my earlier point, why the business judgment rule? Why does it matter? Well, when board members are doing what I just described in that last page, you lose those elements from 2 slides ago where I described the Lambden case. You don't get that protection for showing that the board was acting in the best interest of the association, or was acting in good faith, or was acting in reasonable inquiry. Without those elements in place, that opens the association to not only challenges from homeowners, because they're going to see there's problems in the process, but successful challenges from homeowners. If you get into court and you don't have that business judgment rule as a defense, you better hope that you landed on the right decision. And the fact that you're being sued likely means that you didn't. And so you're not going to have that defense that's built in for corporations. Taking it a step further, as volunteer directors, the law wants to protect you. The law affords you with statutory immunity from liability. That means if you are sued in a lawsuit, you're named personally in a lawsuit, you have immunity from liability, but you have to meet certain criteria. The decision has to be within the scope of your duties. It has to be made in good faith. It can't be willful, wanton, or grossly negligent. And the association has to have the required insurance in place. The insurance is sort of a slam dunk. That should be a given. You should always have that insurance in place. It's one of the most valuable things that you can buy is insurance. The other element should be there as well. But I've had those directors who I've had to look at them and say, I don't think you have this protection in place because of the way that was carried out. For example, I had a director once who took it upon herself to deal with a problematic tenant. And this guy was a problem. A year later, I was involved in the eviction process of kicking this guy out of the community because he was that bad. And the judge did. We won that eviction case. But a year before that, a director decided to take it upon herself to deal with him. And she approached him in the common area, verbally got in his face, and at one point took her lawn chair, parked it in front of his unit, and said, "I'm not letting you get in your unit. You need to move out," and tried to get this guy thrown out forcefully. Well, this guy went in and got a restraining order against her, and the court granted it. The court found that what she was doing was constituted civil harassment. This guy actually, who subsequently I got evicted because he was a nuisance, was able to convince a judge this one director was so abrasive and so threatening with him that she deserved a restraining order. So in that case, I can say that's not within the scope of your duties. And it's one thing to enforce the CC&Rs. It's another to do it very personally and very directly. It was intentional conduct. We can't say it wasn't willful. She was very obviously trying to do this. So you can have those examples where these elements may not apply. And so now as a volunteer, you have now stuck your neck out and you're exposed to liability. This is going to be important towards the end of our presentation today for ways to work with those directors to help them realize this is not the way you want to be serving on the board. There's no reason that any volunteer should be sticking their necks out on behalf of their association. They should have that protection in place. There's another case, and these cases are helpful. These are appellate cases, but having a factual situation helps you understand this issue a bit and how one director's conduct can impact the entire association. This case is called Dean Garden Homes versus Denkis. And this is a case about the approval requirements for painting a home. Mr. and Mrs. Denkis were painting their home. They hired a contractor and they wanted to paint their house pink and green. And they did it without ARC approval. The association then filed a lawsuit to compel them to repaint their house with an acceptable color. Question is, what happens in the lawsuit? Association loses the lawsuit. And here's the reason why. And if you've ever been in a lawsuit, you know it's not just one day you wake up, see the paint, and you're in court. There's a long, long road to get to a lawsuit and to get to a final adjudication. So all these things are happening along the way. The issue is that the homeowner's painter had taken samples to the board president to get his approval of the colors. The board president, not really thinking he was approving anything, said that the green was fine, but they needed to tone down the pink shade. So green color is fine, tone down the pink. That was considered approval. Now, as you can imagine, the board at the time, including that board president, did not think that was approval at all. They thought that was just being friendly and offering a friendly comment to help a homeowner in painting their house. They obviously filed a lawsuit against this homeowner, thinking that they had all their ducks in a row. They had done everything correctly. This was unapproved paint. So they went down this path thinking we had this homeowner dead to rights. They did not paint with approval, and we're going to make them change that color. Turns out that very small conversation that happened probably 2 years in the past, at the point this case is decided, that comes back to bite the association and they lose. Homeowner gets to keep the paint color and the association's paying their attorney's fees and costs, which in cases like this, on an average architectural dispute like this case today, I can tell you that to get that case to trial, you're looking at $100,000 plus to litigate a case like that, because the litigation process takes so long and it's so drawn out. And a lot of it is being responsive. It's not all the association that wants to do all that work. It's responding to the other homeowner in what they're doing. I mean, I have a case like that where the other side served us with discovery requests, and it's going to be $15,000 to answer all the questions that they've asked because they've just really heavily litigated the case. So the takeaway is that unilateral action by the board president thinking he was just helping someone out really can come back to bite the association. So it's important that as individual directors, you know that your words matter. I had a director once, again, probably best of intentions, although she's turned out to not be such a great, helpful director in the long run. But she said, you know, this whole collection process is really impersonal. We send letters, they're threatening, we tell people we're going to leave their houses. We should go door to door and talk to them about their delinquency. And when I heard that, all kinds of alarms go off in my head about fair debt collection practices and everything else. And I said, no. You have to understand that you can't go out and speak on behalf of the board to homeowners directly. Because first of all, you don't have authority to do it. The board doesn't authorize you to do it. You can't agree to waive late fees. You can't agree to payment plans. So what are you going to talk to them about? Almost nothing at all. And if you do commit the association to something, we're stuck with it. So you can't do that. Second of all, what you say to the homeowner and what they remember hearing a year later are probably going to be very different things. They're going to think that they heard you say one thing and you're going to say, no, I said something else. And then we're stuck. Second of all, there's all kinds of issues with debt collection that you have to be careful as to what you say, and knocking on someone's door is not always the right answer. So it's those little things where as directors who want to get out there and do things their way, don't think that they're stepping into a big problem, but they may very well be. And I can tell you the board president in Dankis did not think he was stepping into the bear trap that he ultimately found himself in, and the association did at the end of that case. So what can we do to try and get some controls on this? We have all these issues. We see the good board member, the bad board member. How can we rein this in to try and work together as a board? Well, one step you can take is a code of conduct. A code of conduct is a code or call it whatever you want to call it, a policy that is adopted by the board that creates sort of a benchmark for acceptable conduct amongst directors. It outlines obligations and the consequences of meeting those obligations. Now, don't get too excited about the consequences. There's not a lot of direct consequences that are going to happen, but really the exercise of doing the code of conduct creates a system of accountability and gets everyone to publicly agree to be on the same page on certain activities. The code of conduct can address the roles and responsibilities for the board versus management. So explaining that management is going to be the one who oversees contractors and communicates with contractors and vendors. We're going to have board liaisons to committees, but the liaisons are not going to be voting members of the committee. They're just going to be there to be a conduit of communication between the board and the committee. And I've seen a lot of scenarios where board members sort of take on this greater role when it comes to a committee and sort of tells the committee what to do, but then also goes back to the board and sort of lobbies on behalf of the committee, and we get a very muddled role there. Having that liaison role defined in that code of conduct helps manage that relationship between the board and that committee. Reminding directors and everyone agreeing, even though they have to anyway, to maintain the confidentiality of executive session information and describing the repercussions for violations. Executive sessions are meant to be closed meetings to protect the privacy and the rights of others. They're really not meant for the board to conduct business behind closed doors. Often what directors think is they think we shouldn't be doing things behind closed doors. We need to go out and inform the members what we're doing. Well, I am a big proponent of transparency, but when you're talking about a homeowner who's in delinquency or a vendor who is having a contract dispute with the association, who maybe we have some issues with, or you're talking about a homeowner's violations, it's somebody else's privacy that's at stake there. It's not a matter of being transparent. It's a matter of protecting somebody else's privacy. Because if we violate their privacy, that then comes back on the association and we have some major issues there. Setting aside personal interest in advancing the interests of the association. Again, something that's a given, you have to do it anyway, but articulating that and everyone agreeing or putting the association's interests first can be a helpful exercise, particularly right after an election. And that's the key time to do a code of conduct, is right after a new election when people come on the board. Because a lot of people can come on the board really not knowing what it means to serve on a board. I've done a couple board trainings the past 2 weeks, And in both trainings, it was interesting that the new director said, I don't understand how the agenda is set. I feel like I'm just being told what's on the agenda and I have no say in it. And the first thing we had to explain to them is, no, you have an equal say in the agenda. You just happened to get on the board when the agenda for the next meeting was already set. But by all means, you're involved. But it's that level of misunderstanding as to what the board does and how it operates that as board members who have served for years, you sort of take for granted. But having this meeting where we can tell board members that, this isn't like being elected to public office. You don't have a constituency that you serve. You serve the entire community, not just your own neighborhood. And you can't really come on with an agenda to serve sort of your people, your own group. You have to serve everybody. In kind of getting out of that mindset of that public office mentality and thinking more of a fiduciary mentality for an entire corporation is helpful with doing that code of conduct right after an election. Respecting and abiding by and carrying out decisions of a majority of the board. Again, as I mentioned earlier, when the majority makes a decision, it's important for all directors to get behind that decision and carrying it out. Again, not if it's unlawful, not if it's way out there, but by and large, being there to support the majority's decision, or at least not interfering with it. And one thing that I often remind directors during board trainings is, you may have been on the losing side of a 3-2 vote this time, but next meeting, you may be on the 3-2, you may be on the 3 side, you may be on the winning side of that vote. And the last thing you're going to want is that those no voting directors to start lobbying against the decision that you made. It's important for the board to recognize that reasonable minds can differ, but we have to get behind them what the majority decides. And then finally, treating fellow directors, homeowners, and staff with respect. Again, a fundamental principle, very basic, very low level there, but having everyone agree to that in a code of conduct that everyone signs is a valuable exercise because everyone's committing to that. That you can't just assume that everyone's on the same page. We now know everyone's on the same page because they've signed that code of conduct. Then 6 months from now, when a board meeting goes south, you can pull that out and say, hey, Director so-and-so, you agreed to treat your fellow directors with respect and with courtesy and professionalism in meetings. It doesn't mean we control anyone's speech, but we can say to a fellow director, look, we all agreed that we would go by this, and the way that you just shouted at all of us is not meeting this code of conduct, and we'd like you to get back to that, honor that commitment that we all made when we got on the board. Just taking it a step further, now we have that issue again, that time when the board member unloads and the rest of the board at a board meeting. Getting out that code of conduct, that's the first step, getting them back to that, referring back to that. But if the behavior continues, the pattern goes on, you continue to have issues. Now let's talk at ways to respond to that. First one is a censure, dealing with the board member and the different methods of censure. Let's start low. The board president or another director and management meet with the board, an informal meeting, and explain the issue. Talk about the issue, talk about what the problems are, how we can't continue on in this fashion. Keep it non-threatening, non-embarrassing. Try and get that director to sort of turn the corner and get back to a more productive method of conducting board meetings and conducting business. If that doesn't work, take it a step further. Have the board talk. The entire board meeting or the entire board meets with the director and do it in an executive session. It's going to fall under a personnel matter to maintain the privacy of that director, because if a director is already combative with the board, if they're called out in a public open meeting, they're going to get defensive. Any of us will when we feel like we're publicly embarrassed. So it doesn't go well when you do those public censures. And so it should really be a last resort. Doing it in a private setting can make the director feel like, we're not trying to embarrass you. We just need to change this behavior because it's not acceptable. And not only that, it's exposing you to personal liability. So then go back to what I discussed earlier about that statutory immunity from liability. The way if a director's acting too far out there, they're hanging out there in the wind. They don't have that protection. You may not have D&O coverage. Your D&O policy may say if a director is acting in bad faith or intentional misconduct, it's not going to be covered by insurance. The business judgment rule might not apply. The behavior is not in good faith or in the best interest of the association or done without reasonable inquiry. It could expose that director to liability and the association to liability. So helping the director to understand we have to work here as a team, or else not only you, but all of us are exposed to potential liability. Then do a written notice and repudiation to association members. So on this one, this is not a public embarrassment, a public shaming, a public calling out. We're not using names in this communication, but the purpose of this communication is to remind members that any communications that are official communications from the association are going to be from management or the board president. Any individual directors do not have authority to bind the association. They don't speak for the board. They don't speak for the association. This is important to sort of neutralize those Denkis type issues. Denkis, where the board president approved the paint color. We're putting everyone on notice. Those don't count. Those are unofficial communications, although in that case, it was the board president. But with other directors who are out there making comments, making statements on Nextdoor, binding the board to decisions, we're letting the homeowners know these communications are not official, only rely on management or the board president's communications. Repudiate improper statements made. Again, without calling somebody out, but if false information has been put out there, like a director, for example, goes out and says, oh, the board just depleted your reserve funds by, painting the clubhouse 5 years too early. If that's not right, correct that information. Get out there and respond publicly, provide data. Don't get argumentative, don't get combative. It's only going to escalate things, but provide data. Say, well, actually, that's not correct. Here's our reserve study, and here's our reserve schedule, and here's what the cost of that project was. And neutralizing those statements before they can cause harm. And in some respects, making that director seem like that they're not fully informed in their statements will not only get right information out there, but make members realize, okay, maybe this director is not quite speaking in an informed fashion. We should probably question some of the things that director is saying. Similarly, get out to vendors. Let vendors know this person does not have authority to speak for the association. Landscape company, if you get a call from this director telling you to do your job differently, they don't speak for us. Don't listen to them. Don't take their calls. The only one who can direct you is management, for example. That's going to be important because you can't necessarily stop a director from contacting vendors. I mean, there's just physically no way. You can't like take their phone away or their email away, but you can go to the vendor and say, you're going to get calls from this director. He wants to call you, once a day to tell you about the irrigation, how you're doing it wrong. Please don't take direction from him. Please take direction from the management or the board president, whoever it may be. And I've had that happen. I've had to help directors write in those letters because the vendor started saying, this person's calling me like 3 times a day to complain about things. And I don't know to respond to him or to respond to management. I'm not sure who's in charge there, but it'll help you not only to have the relationship with the vendors, but to make sure the director is not signing you up for big bills, because of what could happen is you may find out that this director has been authorizing change orders and work, or increasing costs by changing out materials or hours of service. And the vendor is going to rightfully rely on that unless you tell them this person doesn't have authority to speak for us, and we don't plan on paying for change orders as a result of this person's statements. And then another step would be to form a litigation committee around this director. So if you have a director who, for example, is directly engaged in a dispute with the association, which happens, or they're sharing information, they're sharing privileged information about executive session meetings, about pending lawsuits, about contractor disputes, form a committee and box them out of those communications. It's not an ideal situation, and it is one of those last resorts. Yeah. But if you have no other choice except to protect the information, then this is the answer: is you have to isolate that person to protect the association and to protect the third-party rights of others. And we had that happen before. We had a case once where there was a pending lawsuit, and one director was very close and very aligned with the plaintiff in that case against the association. And so the board had to isolate him from any discussions about the lawsuit, because the concern was he would turn around and share it with that particular member. And that's happened on a number of occasions. So having those executive committees or litigation committees of the board can be a way to protect the information. It may not change the person's behavior, but it protects the information and protects the association. And then finally, the question I often get is, well, why can't we remove them from the board? Well, the answer is you cannot. You cannot remove a director from the board. The board doesn't have that authority. You can strip their officer titles. So for example, you can tell someone you are no longer treasurer. You're still a director, but we're going to make Director Joe the treasurer, and you're just going to be the director at large now. That may or may not have an impact on somebody. Certain officer positions like treasurer do have more access to financials, so there is an actual physical difference in access to records, or at least involvement with records. Anyone can still see the records, but they may not have the same authority. But symbolically, that can make a difference if somebody loses that officer position, because that's a point of pride, to be the officer of a corporation. Again, you can't remove them from office. In some old bylaws, before the election laws changed last year, we'll have language, for example, that says a director must be in good standing. Well, that is now stripped down to essentially a director has to be current in the payment of assessments with a few other qualifications. If they have outstanding CC&R violations, that doesn't disqualify them. The old corporations code language that's in a lot of bylaws says a director cannot have missed more than 3 consecutive meetings. That language has been neutralized by the law last year, so that language is out also. I've seen bylaws that have said a director cannot take actions that could potentially harm the association. Again, all those potential qualifications were eliminated by Senate Bill 323 last year, which is the election law change that required you all to adopt new election rules. So there's really no basis for the board to remove a director from office. Homeowners can through the recall process, but that's a whole other thing, and that's typically a homeowner-led movement, and quite frankly, recalls are very disruptive to communities. So it's not, even if it is possible, it's not something that the board's going to be involved in, but the homeowners still could remove a director from office. But the point of this is that since the board can't vote someone off the island, using the old survivor terminology, it's important to find that common ground, to work with those directors, to use these different tools of a code of conduct, of having these conversations, of emphasizing the risk of liability, of emphasizing the fiduciary duties that directors have, doing board trainings, doing seminars like this, to help those directors come around and work with the board. You may not agree on all things. You may not agree on parking rules. You may not agree on the schedule for maintenance. There may be different things you don't agree on, but there are some things you agree on. Everyone got on the board to serve the community. So finding that common ground, doing some goal setting, seeing what things that there's commonality on will help. But using these different tools to adjust the relationship, to find ways to work better together, are really the long-term solution, because you can't just take them off the board. They're elected by the members, and so they stay on the board until the members decide otherwise. So finding those different ways to work together is the ultimate long-term solution to dealing with those difficult directors. It is always important to rely on your professionals in doing this. Get your attorney involved to do a board training. That's often why I do them. As you see, I do them when there's a difficult issue, a difficult director on the board. That's often when I'm doing board trainings. Doing them after elections is a great time to do it. Use your management staff. Your management staff deals with boards day in and day out, multiple times a day. That's all they do. And so relying on them to come in and do board trainings, to work with boards, to work with difficult directors, that is a resource that you have at your disposal. And your managers are invested in a high functioning working board, so they're going to be happy to jump in there and get involved and use those professional resources to help you with this. You don't have to fight it out on your own. Those resources can really help you turn the corner on those situations and become a more pleasant board to serve on and a more successful board to serve on. So that brings us to the conclusion of our presentation, but now we have time for questions and answers, and I've been seeing the chat thing, the chat signal flash. I'm hoping you have some great questions, so now I'll stop and give Dwayne and Kira an opportunity to put those questions out there. Dwayne, you're still muted. I think you're still muted, Dwayne.
There we go.
Oh, there we are.
Okay. Right now, we're going to do our Q&A, but thank you, John. A lot of fascinating information that you provided. And I want you to know, if you want a copy of John's presentation, just send me an email and we'll get a copy to you. Plus, this particular webinar will be on our AMC page on YouTube soon, which we're working on. So just a little information for you, all right? Don't leave though, because after the Q&A, we're going to have a raffle. So hang around for that. I think we have a question, and our first question is from one of our attendees, and I'm going to let her ask that question. It's from Deborah Sullivan. Deborah, I'm going to unmute your mic, and I'm going to allow you to ask your question directly if you want to, okay? Are you there, Deborah?
Yes, I'm here. Thank you, Dwayne.
Okay.
Okay,
Answer
I can ask my question now.
Yes.
Okay, thank you. Hi, John Hansen. It's Deborah.
Hi, Deborah.
I want to say thank you for taking the time to do this. What do I want to call this? A workshop. Really great information, and you guys should do this more often. But I wanted to ask, if a bad board, you appoint somebody to the board, they're not elected, but they're appointed by the directors, and they start to act up. Can they be removed if they were appointed by the board of directors?
That's a good question.
They weren't voted in, but they were appointed.
That's a good question. It's actually a pretty complicated issue. So the baseline answer is no, they really should be only removed by a recall of the homeowners. But there is some nuanced arguments under the corporations code about that. So that would be an issue that I would say, because it is so nuanced and complex, that would be a conversation with an association's attorney about what their bylaws say, how that works with the corporations code, and if there's any difference there on how that situation could be handled.
Okay, and I have one last question. Regarding, you have a board of directors, and say you want to make some decisions about the parking and how it should be diced and sliced. Is it okay to have the board vote on those type of issues? If there's maybe one person may not agree with it, let the vote stand on how it's done?
Say the question one more time.
You have a board member, and we have some issues with parking. And we're going to make some decisions on how the parking is going to be distributed. One person may be against it. This is a director. Or maybe two may be against it. Is it okay to have debates about it and then let the vote stand on how it's going to be done? When we have board members that can't seem to come together. Of course, we're supposed to do what's good for the community, the greater good of the community always, not personal stuff. So what I'm asking is, can votes take the place when we can't see eye to eye on how to do things? Can we just have votes on it and go with it?
Yeah, the short answer is yes. Having a consensus amongst the full board is great. But if that's not the case, then what the corporations code said is that a majority decides, and that's the answer then, that whatever majority decides.
Thank you. You've answered my question. Great. Appreciate that.
Thank you, Deborah.
Thank you, Dwayne.
The reason that we have these events, and we're going to be having these workshops the last Wednesday every month, and hopefully in the fall we'll get back to live events. But one of the reasons that AMC has these events is to educate the community and to share information with you from experts like John Hansen. So are there any more questions? I'll give you a few minutes and we'll see if there are any more questions. By the way, John, I like your graphics very much, especially the Bart Simpson graphic.
Yeah, that's a funny one.
Brett, Dwayne, this is Barbara. I have a question for John.
Sure.
So you said the new election rules, if your bylaw stated if somebody meets 3 or more meetings in a row, if he misses them, that the new election rules changed that you couldn't have somebody removed from the board for failure to attend regularly. So if you have someone that misses 3 or more or longer, and you have another willing homeowner, how do you address that? I mean, it's kind of hard to find common ground when they're not coming to meetings or participating. I mean, I thought that was the whole reason they had that in the bylaws.
You're right, and it was a good rule in the bylaws in the past under the corporations code, and it's one of those unfortunate byproducts of SB 323 to lose that. So what I recommend with those directors is to have a conversation with them to say, look, if you're not going to go to the meetings, are you interested in serving on the board? Because if you don't want to go to the meetings at all, the best answer is just to resign, because why continue your name on the board? But then the next thing I tell them is, look, as a board member, you're a fiduciary. That means you are responsible for any actions the board is taking. And that means when there's board meetings that you're not going to, or the board is taking actions, you are just as on the hook as everybody else is for whatever those decisions are being made. So for all you know, the board could be sitting in a meeting making decisions that you completely disagree with, but because you weren't there to offer any input, you're going to be right there with the full board on whatever that decision may be. And you can't really get too crazy with that, but hypothetically, if I'm a director, the board, and I'm not at a meeting, the board could be there and they could be deciding to, all write themselves reimbursement checks for $10,000 for all of their hard work over the past 2 years. And I wasn't there to know about it, and I couldn't object to it, and I couldn't, state my objection on the record. When that lawsuit comes over that issue, I'm right there with the rest of the board because I was a fiduciary and I was asleep at the switch. So, of course, you can't use that kind of crazy example of somebody because you don't want to make it sound like the board is being that outlandish. But the fact remains that directors should not be staying in their roles if they're not going to be actually carrying those roles out. They're really exposing themselves to risk. And that conversation could result in somebody saying, all right, I'm not willing to pay attention, so I'm not willing to stay on the board, I'll resign.
Thanks, John.
Or they'll start coming to meetings, which would be ideal.
All right, ladies and gentlemen, this is our last call for questions. If you have any questions, you should chat them now. Otherwise, we're going to move on in our agenda. So we're going to give you a couple of minutes. Any more questions? All right. We're going to move on to our raffle. But before we move on to our raffle, let me just say a few things about AMC. As I mentioned, Baydaline Jacobsen is one of the partners that we work with, and one of the vendors that supply this wonderful information for us. And when we put these events on for you, we encourage you to ask questions, and we encourage you to reach out to us if you need help with your association in any way. And what I'd like to do with the raffle is have John move forward and select a number, John. What we've done is we've assigned everyone that is one of the participants today a number. And John, if you would select a number from 1 to, let's see, we got 19 people here, from 1 through 19, and that will be the winner of the raffle, unless it's an AMC staff member.
Dwayne, can you hear me?
Yes.
You didn't see my chat. I have one last question for John, clarification. This is Deborah.
Okay.
Please, and it will be quick. I just want him to give me clarification on a board member not attending a meetings. My understanding is a board member misses 3 consecutive meetings, no letting anybody know why they're not coming. You mean to tell me, is our thinking anyway, that they can be removed? Am I hearing that that's no longer the case?
Correct. That's no longer the case under Senate Bill 323 that took effect last year.
Wow. So do they have to write a letter of resignation before that they can get off the board, or they have to be voted off when somebody else runs?
Well, the homeowners could vote them out either through a recall or through the next election process.
Yeah.
But the board member themselves, they could resign. And often once you have the conversation with them about if they want to serve, they may often say, I don't really want to serve. It's too hard for my schedule, or whatever the reason is. And if they resign and there's a vacancy.
That's acceptable?
Yeah, if they want to resign, that's fine.
Okay. Thank you. I have clarification now. Sorry for that.
That's okay.
Thank you for answering me.
All right, well, the random number that I will pick is number 7.
Wow. Okay. Number 7 is Mr. Don. It is Schubert. Scheibert. Don Scheibert. Okay. Well, Don, excuse me if I mispronounce your name, but we will reach out to you. You have won a $50 Visa card, courtesy of our sponsor, Farmers Insurance, Carlin Insurance Agency. So congratulations, Don. We will get you your raffle prize. Now, in closing, let me just say that our next AMC workshop will be on June the 30th. And on behalf of the entire AMC family, including our president, Mr. Brad Higgins, we want to thank you for joining us. And we hope that you will join us for our next workshop next month. And remember that if you know anyone looking for an exceptional HOA management company, have them call AMC. And with that, we will close the webinar for today. And I want to thank you again and thank our sponsor, Farmer Insurance, Carlin Insurance Agency. Everyone have a great day and we'll see you soon. Thank you.
Thank you all.
Thanks, John.
Thank you.